All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here today on our case number 1CA-CV170397, Ronald Colin Dew and Acme Home Services versus Arizona Registrar of Contractors. Counsel, as you know, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you both if when you approach the podium you give us your name and the name of your client. We have studied the record in the case. We've also reviewed the briefs. We've also discussed the case in our conference this morning. So with that, counsel, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Adam Anderson. I represent appellant Mr. Ronald Dew in this case. I don't want to repeat everything that you've read, although I'm not sure I can help it. So please bear with me. If you have a question, I expect that you will ask that. As you know, the registrar cited Mr. Dew for conspiring on 491 consecutive days. ALJ Lang found Dew liable for contracting without a license on 491 consecutive days. Mr. Dew asked for a rehearing for, among other things, there not being substantial evidence on the record. That petition triggered a process. The Superior Court had an obligation under statute and the law to review the record. She did not sit to weigh credibility to try the case again, but she was to review the record. Had she reviewed the record, and there is no indication from what I can tell in the Superior Court decision that the court did anything other than repeat the record. Had she reviewed the record, she would have found, we claim, no substantial evidence justifying the finding by ALJ Lang that Mr. Dew had contracted without a license. I will get to the disjunction between the citation and the finding later on. But I want to start with this premise. There was no substantial evidence. The evidence presented by the ROC at the hearing, at the administrative hearing, consisted of a signed agreement that was essentially on day one of the conspiracy. That agreement specifically said that Mr. Dew was not going to engage in contracting activities. That's one piece of evidence. The registrar presented evidence of 13 complaints, commonly referred to as ROC complaints, against a claim. Of those 13 complaints, and this is record, it's so much easier to find when I'm practicing. 45. And record 45 is a sheet listing 13 ROC complaints. Two of them, and these ROC complaints are against a qualifying party, Davis. Dew is not on this sheet at all. Davis is there. Two of the complaints against Davis are against companies that existed years prior to the agreement that we're talking about. So they have nothing to do with Dew. One of the complaints is against a different Davis. So 3 of the 13 right away have absolutely nothing to do with Dew. That reduces us to 10. 5 of those complaints were closed or otherwise dismissed with no discipline at the time that they were presented as evidence. There's no evidence of any contracting or anything going on with that. So those 5 are gone. That leaves us with 5. 4 of those complaints were still open. meaning no decision had been made. There's no evidence from those at all about any contracting activities, about any conspiracy, anything. The one remaining was this matter. So that's evidence that was presented, but that's not evidence of contracting without a license. It's not evidence of conspiracy. So you have the complaints, you have the agreement, and there was one invoice submitted as evidence. That, I believe, is record 50. That is an invoice that comes, if you're looking at the days of conspiracy, it's about day 239. And there's no evidence in the record as to what that invoice represented. It has, the testimony had to do with, is that Acme's number? Is that Acme's name? Yes, yes. There's a list of items, but there's no telling whether those were parts that were sold and delivered, if there were services provided. There's no...
Counsel, let
Yes.
me ask you a question. So it's your position that the Registrar of Contractors violated your client's due process rights and did so by imposing penalties not included in the CDO, civil citation, or notice of hearing. Is that fair to say?
I think that might overstate our position a little bit. I think I'll concede that the CDO is close enough to mentioning contracting without a license, which is what the ALJ ultimately finds Mr. Dew of doing wrong, I will say. But our position on the due process argument, this is the legal argument aside from the facts, is that the CDO is not the citation. The statute is clear as to what the citation. The CDO tells Mr. Dew, listen, we think you may have been involved in something here. It lists the whole statute out, and it says stop from this point forward doing anything like that. Then there's a separate document that is the citation. And that citation, which is in the record, lists 491 counts of conspiracy. It is specific. The statute requires that the citation be specific. And the ROC was specific. It pulled one clause out of the statute that's included in the CDO, the conspiracy clause, and repeats it 491 times. So the due process, to answer your question, Your Honor, the due process was violated in citing him with conspiracy and then ultimately finding him liable of something altogether different.
All right, but you didn't raise this issue before the ALJ, did you?
That issue, that's correct. That issue was not raised before the ALJ. Mr. Dew was not represented at the time, and our position is he was in there.
He represented himself.
He represented himself.
Which he has a right to do.
Thank you. That's correct. That's
So-
correct.
Go ahead.
And we hold self-represented clients to the same standard as represented clients, don't we?
Absolutely. And I don't mean to excuse him for that. That's just a fact. But in there, I'm not sure, I don't want to self-disclose too much, but I'm not sure that sitting there in the heat of battle, I would have gone back necessarily and looked at the citation that is, 6-7 pages long of repetitive stuff and said, wait a second, that was for conspiracy. What we just talked about here had nothing to do with conspiracy.
Well, it does, the evidence did have everything to do with conspiracy in the sense that, as I understand it, the evidence that would be offered to show that Mr. Dew aided and abetted, conspired, or flat out contracted without a license is the same evidence, because the evidence would have to show that the real contracting party was not Allied but was Mr. Dew, and whether you charge it as Mr. Dew conspired with Allied to have Allied enable a non-licensed party to contract, or aided and abetted, or did it himself, it seems like the facts would be the same. But here's the thing, as you say, the citation was charged as conspiracy. And under in other cases, and not having to do with the registrar, we say conspiracy is a single offense. What would have happened differently at the hearing if you'd been there, if another lawyer had been there? What evidence would have been offered at the hearing to show that he didn't conspire on each of those days? How would the hearing have played out any differently? Why am I wrong in thinking the evidence was the same?
I'm not sure that you're wrong about the evidence. They're clearly, for conspiracy, right, they have to present an agreement. There's one written agreement, all right, that I don't think shows conspiracy to defraud the ROC, essentially, right, to contract without a license. So then, if you disregard that agreement, they have to show evidence, A, of an agreement on every day. There was no evidence of an agreement on every day. Now, it could be inferred, perhaps, on day-to-day operations. So let's assume, all right, there's an agreement every
This is how we're
single
going to
day.
operate. You don't need to go to the field unless there's a complaint.
That's right. Okay? So let's assume that. There still has to be evidence of work that qualifies as contracting. And there was none.
For each of those days.
That's right. For one day, right? To get anything at all, there has to be evidence of contracting.
So that goes to your argument on sufficiency of the evidence, not on whether there was a due process violation. In my reading of the record, and correct me if I misunderstand the record, is that everybody practically understood that what was at issue was contracting without a license. That's how the ROC presented the case as a practical matter. That's how your client defended on the matter. And I guess my question is that even if the citation should have listed that statute and it didn't, what harm, what prejudice did your client suffer from that omission? And I take your point on the sufficiency argument. You're speaking about the process.
So what harm, and I just want to make sure that I'm understanding, I think I do, right? There's the sufficiency of the evidence and that they're so intertwined that I apologize if I cross the lines. We're trying to separate right now the sufficiency of the evidence, right, which we've sort of talked about, and what prejudice, just because everybody knew we were there, let's assume it, right, on contracting without a license question, because it wasn't cited properly, what prejudice did Mr. Dew suffer? And I think my answer is, I guess, would it have changed his presentation? Maybe not, right, if the citation had been correct. But formalities are important, I think. And so is there a practical harm because his due process was violated? Maybe not, because everything kind of played out in the way that it would anyway, right? But when you go back and look at these things, the ROC has an obligation. And I'm grateful for what the ROC does, right? There's a place I can complain when somebody does something wrong. But they can't sit and just say, well, we don't like this guy for reasons justified or unjustified, and put him through just a kangaroo court to do that. Due process is important.
So so your argument is that because ROC had the obligation to cite the right statute, it didn't. That warrants reversal, even though as a practical matter, your client suffered no prejudice.
On the due process part of it, I think that's a fair statement.
All right, thank you.
Why? Okay, then tell us why the failure to put Mr. Dew on notice that he faced $491 times $250, $2,500. Why is that not a violation of due? Why is that a violation of due process or otherwise requires reversal.
The failure to put Mr. Du on notice of, I'm sorry, Your Honor.
I'm sorry, it's one thing to put him on notice that he was going to be charged with contracting without a license, and that was the case that was tried. Is it another thing to put him on notice that you might have 491 days of fines?
Well, and that is absolutely, and I appreciate that, Your Honor. If I can maybe talk a little bit about that. There's the conspiracy, right? You walk into a proceeding, and they have to prove 491 agreements to get me on this, right? Even if everyone shows up and we're really talking about contracting without a license, there's still a notice provision. And he knew what the ROC had subpoenaed or failed to subpoena. And there are essentially nothing. There's no evidence there. So he walks in understanding what evidence is going to be presented. He knows that he didn't agree 491 times, and it's going to be a hard battle, an uphill battle for the ROC to prove conspiracy. And all of a sudden, everything changes on him. Now, that's a preparation problem. If he had known, hey, I'm going in to talk about contracting without a license 491 days, he could have gone in and said, well, first of all, there are weekends. I didn't do anything on weekends. There are holidays. There are days that I was sick or the office was closed. I mean, whatever, right? We can knock 491 down to whatever number that is. And then I can show, for the most part, we were answering telephones. That's not contracting without a license, right? Or there's no evidence. Now we're back into the evidence part, but it's the preparation. It's the preparation. What evidence do I need to be prepared with to argue conspiracy versus what evidence do I need to be prepared with to argue contracting without a license?
So,
and the
counsel,
rug got pulled out. I'm sorry.
Counsel, back to the issue of due process. So you've indicated and you admit that you did not raise the due process claim before the ALJ. Now, why is that argument not therefore waived?
Well, thank you, Your Honor. There are, I think, two answers to that. First, not raising it with the ALJ, he did not know, even though there was the trial, he didn't know what the ALJ was going to do until the decision had been rendered. He really, I mean, I don't know that it's fair to put on him, Your Honor, we've argued a case that wasn't noticed, and in case you plan to decide on that case that was never noticed, that's a violation of my due process. He had no idea.
Well, but how does that argument square with the principle that if you don't raise an issue before the ALJ is waived? I mean, because anybody in this circumstance of the crime, I'm sure it happens all the time, to make that very argument. And if your argument is correct, then there really is no waiver.
And that's fair. So let me move to point two, because I will concede that, all right? There's a problem, absolutely a problem, with when Mr. Du raised the due process argument, okay? I think that problem gets fixed with the sort of fundamental error and Rule 60B. All right, Rule 60B allows a tribunal to look at something, and look at a judgment, and decide, is that correct? Is that proper? And in this case, and in many, many cases, right, you fail to raise something, and well, you've waived it, and that's okay. In this case, I don't want to overstate it and be overly dramatic, right? But Mr. Du got hit with the civil equivalent of a death penalty for himself. $1.2 million coming out of something for contracting without a license that he wasn't even noticed for. That's a big deal. That's a big deal. And I think looking at the fundamental error and going back and seeing, well, look, the ROC did it wrong. The ALJ was sort of complicit. The Superior Court looked at it and did not review the evidence. This gets into the evidence, I understand that. But looking at the whole package, right, under Rule 60B, this tribunal can look at that and say, that's wrong. And there was fundamental error committed.
You argue fundamental error in your briefing and your argument today. What's curious about the argument, though, is that well, I'm a former prosecutor, so I'm familiar with fundamental error. These are all criminal cases. I mean, do you have authority that the concept of fundamental error applies to these types of proceedings?
I don't believe that we've been able to cite anything. We're arguing by analogy. Thank you. Okay. I have a minute. Are there other questions? If not, I will reserve the minute.
Reserve it, thank you.
Thank you.
Good morning, and may it please the Court, Assistant Attorney General Michael Rain on behalf of the Registrar of Contractors. Mr. Dew has waived his due process arguments. He didn't raise them at the administrative level, but moreover, he didn't raise them at the Superior Court. He didn't raise those arguments until for the first time after the matter had been appealed to this court, and the matter was remanded back down to the Superior Court to address this limited issue of whether inclusion of the transcript in the record would have changed the Superior Court's decision. Mr. Dew seized on that opportunity to raise a whole host of new issues, and so the waiver issue is essentially a double waiver. I mean, he waived it in two straight proceedings.
Okay. But tell us why the case wasn't charged differently. It was tried as a contractor without a license case. Why were 491 separate paragraphs copy and pasted with conspiracy, not something else?
I don't have an answer. The record doesn't answer as to why only the conspiracy portion of that statute was referenced. As we've noted, this was a single document. 321166B requires, if the ROC is going to issue a civil penalty, it must include a cease and desist order. This was a single issue, but it was also a single document, the very same document that contains the cease and desist order, which includes the entire text of the statute, the conspiracy statute 1154A9. It also references 321164, which deals with unlicensed contracting. It's not only the same document, it's the same page of the same document.
I see it right here in front of me.
And ultimately, I'm sorry, Your Honor.
If the charging if the cease and desist order and the citation had listed only conspiracy 400 times, that's one offense, right?
You know, the cases that they've cited out of the federal courts relating to criminal conspiracy and a very specific federal statute, that's what they held.
And under Arizona case law, too. I mean,
it may well, I haven't seen that because they haven't argued it, but assuming that's the case, this is, I think, a bit of a red herring because the ROC's case wasn't a one conspiracy case. It cites to 321154A9 in its entirety, quotes the entire language of the statute, and one argument that the appellants have raised in their brief is no one ever even mentioned the words conspiracy in the hearing. No ROC witness, no attorney for the ROC. This wasn't a single conspiracy case. The notice makes that clear. It doesn't say, oh, on such and such day you entered an agreement and therefore you're in violation. It says, first it begins with the long history that Mr. Dew had with the ROC, and then it goes on to say how he's combined with Mr. Davis to do to run a claim error, and it says now he's running the day-to-day operations. And then it goes on and lists the length of time that he was operating. So inherently, it wasn't describing one single event. It did reference the entire text of the statute, and it used, as I understand it, at least my impression of it, is a shorthand because it was about to list 491 separate days. I think, in hindsight, I'm sure they wish they just cited the number of the statute without quoting any of its language, and then I think we'd have no question whatsoever. I'm sorry.
And perhaps I'm skipping ahead, but how does the citation failure affect the propriety of the ultimate penalty? Because the argument can be made that however it was tried, the basis was conspiracy. That's what he was found responsible for, so the penalty can only reflect the one conspiracy, not 491.
When I think we're assuming the notice violation is valid to begin with, and
Citation.
yeah, well, that failing to reference the remaining, failing to consistently reference the remaining portions of 1154A9, the nature of that argument is that it's a due process violation, and as this court, I believe, appears to recognize that there's no actual prejudice from that or the failure to cite 1151.
And he seems to have conceded that.
Yeah. So really the question is, I didn't know you were going to go beyond the conspiracy, but you did. And so the idea of whether the evidence supported the penalty, I think, needs to be separated from the conspiracy issue, because that's really the due process. You didn't tell me the rest of 1154A9 was at issue. That's why your penalty doesn't work, because 1154A9 also includes many things that aren't simple agreements, but combining and conspiring and aiding and abetting and these other terms. So the evidence and the several penalties do require in part the entire language 1154A9, but the fact that it's not included is only a due process argument that they have waived by not raising. I do want to make a point about this idea that somehow he was not on notice that this case was about unlicensed contracting, because the basis, the actual basis of this citation and the hearing notice is not solely, at least, 1154A9. It's really 1166, 321166. That's the statute that gives the ROC the basis to impose the civil penalties and issue the cease and desist order for violation of ROC statutes. So you need to somewhat join 1166 with some other statute to make a complete charge. They joined it with 1154A9. Now, before I go into to discuss that a little more, back to 1166, what that statute says is that the ROC may issue civil penalties and cease and desist orders against someone not currently licensed who is engaging in the business of contracting. It is an unlicensed contracting statute. Similarly, 1154A9 is an unlicensed contracting statute. It says you are combining with someone with the purpose of evading the ROC's licensing laws, that you need to get a license to do what you're doing. 1151, which just says unlicensed contracting is illegal. It provides no remedy or no mechanism for enforcement. I think it would have been relevant as a citation, but certainly not required. If I want to go build my neighbor a house, for compensation, you need that, and I don't involve anyone else, I've engaged in unlicensed contracting, 1151 is the appropriate citation. If instead I purport to be a licensee through someone else who's currently licensed and say, oh, it's me, but that other person has nothing to do with it, I'm just using their license to present a face of licensure to the public, that's an 1154A9 unlicensed contracting issue. So the idea that he wasn't on notice of unlicensed contracting, I think, is not technically accurate, but as some of the questions have, I think, indicated, nevertheless, that's the case that the ROC presented. If putting the notice aside, what actually got presented was that he was engaging in contracting under the definition of that term. It's the defense that he raised.
What about the argument that the evidence was insufficient to support 491 days of violations? In other words, the evidence at best consisted of generalities. Yeah, they were doing this sort of thing, as opposed to on this date this happened, on that date another thing happened.
Well, there was evidence in the record, substantial evidence, to support that this was an ongoing operation commencing with the execution of this agreement. I think it's important to note before I really address that question that Mr. Dew never raised any argument whatsoever that, on appeal even, that his conduct was not as the ROC had alleged and as the evidence had suggested in the hearing, that he ran the day-to-day operations, essentially just to be short about it, that he did every single thing that this business needed to do except for one thing, which was when someone needed to show up because the ROC was going to be there, Mr. Davis, the front man for the entity, would show up. And I think that's actually an aggravating factor.
Can you be assessed a penalty, though, for contracting without a license on a day that you didn't, on a Saturday or Sunday or holiday, when your business was not operating?
Yeah. Well, number one, there's no evidence that
I'm
this...
asking the question, though.
Yeah, no, I understand, but there's no...
State's burden to prove it.
I understand, Your Honor. Yes, you may. And the definition of contracting that is in 3211, 1101A3 has much more than just putting hammer to nail. You don't need to be out there actually on a job site. It includes offering to undertake, excuse me, let me begin again. Undertakes to offer or I'll get it right the third time. Undertakes to or offers to undertake to, purports to have the capacity to undertake to, submits bids, responds to requests for qualifications. It goes on to say does himself, by or through others, directly or indirectly supervises others to do. It has to do more.
But the hypothetical is nothing is going on the 4th of July.
But something is going on the 4th of July. Mr. Dew has maintained this allegedly licensed company. He has a web presence. He has existing clienteles with existing agreements. His phones are active. He's employing people. He is running a business that started on day one. The very first day they entered the agreement, the management agreement, he went to GoDaddy and set up the web presence for a claim error.
And the second says purports, correct?
Yes.
So by having a website or by having this business, even on the 4th of July, they're purporting.
Yeah, and as of day one, but there was also evidence of a substantial nature in the record that it was an ongoing and continuous business and intended to be so. There was evidence that when Abode Air, which was his company that had been revoked 45 times, when it went out of business, Mr. Dew sent out, let me take one step back, the next entity was M-Drive, the entity that, well, actually there was Acme Home Services in between there, but in between Abode and M-Drive, what occurred was he sent out what he called the good news, bad news postcard. Bad news, Abode Air's out of business. Good news, M-Drive's going to go ahead and take care of you. We're going to honor those existing contracts. There was additional evidence that they didn't really need to do that postcard when it went from M-Drive to Acclaim because M-Drive used Acclaim's same phone number, address, and everything of that nature. So Mr. Dew had testified, I didn't need to send the card again because when they called M-Drive, they were just going to reach us. They had the same employees. There was DES records introduced at the hearing that the same group of employees were being paid at the same time by Acclaim, Acme, and M-Drive, all in the same quarter. Same trucks with Acme's name on it, same equipment. They always use the same call center. There's evidence of the complaints that are coming in. I do want to make one note on that. There's nothing in the hearing that actually addressed these 13 complaints that counsel has gone through and I guess looked at a cold piece of paper and tried to adduce what they might mean. But Mr. Dew didn't raise any challenge to that. But nevertheless, what you did hear was there was at least several complaints that were filed, which shows work is being done. Evidence in the record from Mr. Davis, the qualifying party, who's talked about what went on. There was monthly meetings. Evidence from the ROC's inspector about being at the job site where these jobs were happening. And so there was ample evidence that on day one it started, and he's purporting to be a contractor and holding himself out, supervising others, and plenty of evidence about an ongoing operation. Never a dispute whatsoever or any issue raised from Mr. Dew that somehow there was some lapse or end to his business. Furthermore, 321166, which is the statute upon which this action is based, does contemplate daily penalties, not necessarily for discrete acts, but for an ongoing endeavor. And so that's another basis by which that penalty may be justified on a daily basis.
Is there a case you can cite involving the where the court analyzed a daily fine, daily penalty?
I don't believe so. I'm not sure that it has been. It is in 321166, but otherwise I don't know of a case that has interpreted that, Your Honor. I do want to address briefly the idea of waiver. The fundamental error doctrine, at least as I read the case and in candor to the court, it did indicate that it was, I think the language was, it's only sparingly used in the civil context. So I don't read it to mean that it can't apply. But when it is applied, it must implicate, as at least the case is cited in the briefs, an important constitutional issue. So you're only ever going to get to the fundamental error doctrine if you find a notice violation. That's the only constitutional issue that's been raised. And you're only going to have that if you think the notice was inadequate. And even if you think the notice is inadequate, in order to establish a due process claim, a violation of due process claim, you must demonstrate prejudice. And so there's all of those elements that you need to get through just to apply this doctrine, which even in a clear case should only be, sparingly used. And I would say this is not the case for those legal reasons to ever apply this doctrine, but I do want to note that this is also not the party for whom to apply such a doctrine. There was an interesting part in the hearing where Mr. Dew recounted a conversation he had before most of this had occurred. Adobe had been revoked, and he said he talked to his father, and his dad said, and Mr. Dew had already indicated that Abode Air, was a $5 million a year business. And he's talking to his father, and his father says, can you do it again? I mean, can't you just do it again? You built that up. And Mr. Dew said that he told his father, yeah, I think I can, but I can't. I've been revoked. His dad asked him, well, can I apply for a license? He's 85 years old at the time, said, but can I do it? And Mr. Dew said he told his father, well, only if you really know how to do air conditioning. And so his father asked him, well, can't we buy a business? And Mr. Dew told his father, no, you can't do that. That's not allowed. I can't get around it that way. Nevertheless, that's exactly what he embarked to do. Through his father, 85 years old at the time, they created Acme Home Services. Mr. Dew, I think it was on the very day or the day after Acme Home Services was registered with the Corp Commission, Mr. Dew's father signs a power of attorney giving him complete control of Acme. Well, ultimately, the ROC figured that out. So despite apparently knowing that was not going to fly, he tried it. He got caught. He got a notice of denial of that license that explained, Mr. Dew, you're not allowed to do this. You've been revoked. Nevertheless, undeterred, they tried Mr. Dew, his father's second idea, and they went and tried to buy M-Drive through Acme. I think within a month of Acme's denial. M-Drive ultimately operated the same way it claimed did. Mr. Dew did everything. The qualifying party there was a gentleman named, I think, Rivera, and he testified in that hearing, and this is all within the record, that the only thing he ever did was come pick up checks. Mr. Dew did everything. The ROC figured that out, and it summarily suspended and then revoked M-Drive, issuing another decision that Mr. Dew, one would presume as the person with, in the most generous sense, power of attorney to run the entire company, was aware that the license that company owned had been revoked in an order from the ROC, which, somewhat noteworthy, cited him for a violation of 32-1154A9. It was A10 at that time, but it's the same violation that he was cited for in this case. Still undeterred, he tried option 3, which was to remain completely private with this private management agreement. So when the ROC finally, after about a year of its operation, found him and said, he's at it again. And they cited him for an 1154A9 violation and recounted this whole history. With that history, and with Mr. Dew saying that this was all stuff he knew, was forbidden, to come in and say, I have no idea what this case was about. I was completely taken by surprise. When the record really doesn't express any surprise or any confusion whatsoever, any troubles that Mr. Dew had in any sense as to what are we here today to talk about. Obviously there's no prejudice there, but I think when you're thinking about applying some sort of doctrine that might forgive a waiver, under those facts, Mr. Dew just doesn't deserve it. The penalty was just. This was brazen activity, repeatedly undertaken with knowledge, apparently, of its illegality. Mr. Dew was running a $5 million business at Abode Air, and he's received a $1 million penalty for 1 year of operating a claim, which essentially was just the next version of Abode, Acme, M-Drive, a claim. It was an ongoing, continuous thing. He never shut down, really, other than as he was absolutely forced to do by the ROC's actions. And I think it's noteworthy to note, too, what those licensing statutes are that he attempted to evade. Under the ROC's licensing statutes, if you're revoked, you have a 1-year statutory bar. 1 year. and he couldn't wait a year, apparently, to attempt to apply again. Under the ROC's licensing statutes, if you've had recovery fund payouts, you can't get licensed again unless you pay those. Those were $14,000. Not an insurmountable fine for a business doing $5 million a year, but Mr. Dew never paid that. He never made good on that. He just put a cloak on, purported to be someone else, hid behind, sent out qualifying parties in name only to be the face of these companies when the ROC showed up. And then when the ROC would catch him each time, he'd move on to the next one. And now in this case, he's come and argued, surprise. And I think that should just not fly with this court. And we ask you to affirm the decision, protecting consumers in this state and giving Mr. Dew, I think, a just penalty that will certainly meet the crime and deter any similar conduct in the future. So I thank you. Unless there's any other questions, I have 8 seconds. Thank you so much.
Thank you, Your Honors. Just quickly, Mr. Dew may have done some bad things. He's entitled to the protection of the law. Much of what we just heard has nothing to do with the 491 days he was charged with. Having a website may violate a statute, but the record has zero evidence of what was on the website. We don't know. There's no evidence, and that is a huge point, and that is not waived. Mr. Dew brought that up when he should have. There is not substantial evidence justifying the penalty that was imposed. Quickly, the cease and desist order required in each citation, if you look at Record 42, each one of the 491 paragraphs has a cease and desist order in it. So the cease and desist order up top is different from the cease and desist order required to be put in each citation. That is an important point and goes to the due process argument denying Mr. Dew his life, liberty, and property, if you will. Thank you.
Thank you to both lawyers for your argument, or all the lawyers for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.